Just a further update on the Vine and Barton matter. Some people have pointed out that Mr. Barton also made another tweet. The tweet being words to the effect of, if you see this person near a school, call 999. Now that actually might be a bit of a game changer, because, as I said in the previous video, you've got the mere vulgar abuse. Because of appending the word bike to the front, he had an argument about this is just an insult to do with Mr. Vine's being very much into bicycles. However, that phraseology, if we apply that meaning test, what would your average person think about that? Well, what would you think if you heard somebody say, it shouldn't be near schools? You're more likely to think that is an accusation of the P word. So that does change things, and it possibly explains some of the subsequent behaviour. However, there may be still a get out of jail free card for Mr. Barton. But yeah, that's certainly going to be a problematic tweet, because if it is interpreted as an allegation of the P word, then you can say, well, look, this amounts to a particular offence, it would attract attention of 12 months or more, therefore it is effectively showing it would tend to cause serious harm. Because as I've said, the courts do quite often adopt that approach of allegations of criminality. And this is, arguably, we have these chase levels. Chase level 1, he definitely did it. Chase level 2, there's grounds for suspecting he did it. Chase level 3, there are grounds for investigating whether or not somebody did it. This is clearly a chase level 1 accusation, if the court find that interpretation, which I think they might. So what have we had since then? Well, Mr. Barton has actually made some public offers to settle this matter. He offered to donate sums of money to charity. So what's the effect of that? First of all, people might be saying, well, isn't that him admitting that he's liable? Actually, no. Courts are very keen on people trying to settle things. So even though this is all done in public, it's still arguably what we call without prejudice. And without prejudice, normally you'd mark the sort of correspondence, or you'd state it. We write on letters, without prejudice, save us to costs. Or if we're having meetings, we make sure we swap emails saying, just to confirm this is a without prejudice meeting. So normally, they are by definition confidential, but there's nothing to stop you making your offer in public. And sometimes even in litigation we do that. We will say this is an open letter, and we'll make an offer in there, usually without any admission of liability, or if we're a claimant saying we would accept this. The reason you make them open correspondence is because you can stick them in the bundle. So the judge can actually see those during the conduct of the litigation and any trial. I mean, as to how effective they are, the only reason you're really doing it is to say, hey, look, we're the reasonable ones, or perhaps to explain, why it's taken a while to bring something to court. Because court might say, you could have acted a lot quicker on this. If you were that concerned about your reputation, you can say, well, no, we were reasonably trying to settle this and we just couldn't, and that's why we've had to issue at this stage. So yeah, that's not going to be a problem for him. However, apparently those offers have been rejected by conduct, insofar as far as I'm aware now, Mr. Vine has actually issued proceedings and is asking for £250,000. So what's going to happen? Well, again, it might be that Mr. Barton tries to argue that this is a slap and tries to get it struck out at an early stage. This is clearly just him trying to silence me. I was talking in a matter of legitimate public interest about, Mr. Vine's obsession with bikes or something. That might be a little bit difficult, because one thing courts can take into account when considering whether it's a slap is the tone and conduct of the correspondence so far. Usually this is from the claimant, the claimant side. If the claimant's going all gung-ho and aggressive and I'll see you, I'll ruin you, that's more likely to be a slap. But then again, just sending a standard letter before action saying we say you have done this, and if you don't, if we don't get satisfaction and accord, to use one of those legal doublets, then we will be issuing proceedings. I mean, it's always a fine line between what's a threat and what's extortion and what's just standard litigation conduct. So it'll go for the meaning hearing, and as I've said, I think this case, if it gets to the meaning hearing, that will be determinative. Because if the judge says, yeah, actually, I do accept this is just mere vulgar abuse, that's the end of it for the claim. If, however, he says, no, I find this an accusation of the P word, I think Mr. Barton's in trouble, because, you know, he's certainly not seeking to justify that. You know, can't see any evidence as to how he could do that. But might there be a way out? Possibly. Now, I've got to be very careful what I say here. I can't discuss certain things for all sorts of technical reasons. But people have pointed out that Mr. Vine called somebody else, equated somebody else to Jimmy Savile, and said, you know, you are the Jimmy Savile of the internet. So, it's, you know, can we get into sort of pots and kettles and all that sort of thing? The thing is, it's not necessarily a defence that somebody else did something. The mere fact that somebody brings a claim for libel, and you can say, well, they're always libeling people, the court might turn around and say, well, that's fine, those people can issue. But we have this concept sometimes in law called to cock defence, which is basically saying, well, you did that anyway. Doesn't crop up a lot in regular litigation, though it does crop up in international war crime stuff. Can be a defence to an allegation of a war crime to sort of say, to cock, in other words, well, you were doing this. This happened in the Tokyo tribunals after World War II, when there was certain and indeed in the Nuremberg tribunals, because there were some arguments about the legitimacy of submarine warfare and firing on lifeboats and abandoning lifeboats. And Dönitz was prosecuted. That was one of the charges against him, that your U-boat fleet just leaves people. And also the Luftwaffe have been known to fire on lifeboats. And they were able to show and say, here we go, to show that that's the Royal Navy and the RAF policy as well. Arguably, say, well, just because we did it doesn't mean you get off. It should be you're prosecuted, but we'll prosecute our own guys as well. But obviously that wasn't going to happen. But that's what we call the to-cock defence. And like I say, that's really only something that crops up in international law. We'll have to talk about this sometime. There's a whole concept called reprisal, which has a technical meaning in war crime stuff. A reprisal is where you do something that would normally be a war crime, but you're doing it in response to another war crime. There are all sorts of rules about it. It's got to be proportionate, it's got to have a legitimate aim. There are certain things that you can't reprise on, so you can't do any breaches of the 4th Geneva Convention. That's the one about prisoners of war, civilians, or the 3rd about prisoners of war. So even if somebody is, you know, like the Führer order executing commandos, you can't suddenly start doing that. But you can do things. I mean, that was the justification for mass civilian bombing during the war. They said, well, the Luftwaffe started it. And indeed, the Luftwaffe did drop the first bombs on a civilian target, although the argument was it was an accident. They're saying, actually, we were aiming for an industrial military target, but we just missed. But yeah, so back to Barton and Vine. I think that this has radically changed things. And it just goes to show how just one line or one sentence can make the world of difference. Similarly, you know, you can quite often get out of defamation just by adding an extra line. Oh, I'm only joking, or this is my opinion. Just saying it's your opinion doesn't necessarily get you out of it. It's not an opinion. Similarly, how saying allegedly, that's not a defence, despite what you might have seen on what's that thing? Have I got news for you? But it is probably worth raising that to cock defence, because the big danger for Vine, of course, could be that a judge says, I find you have been defamed, however, because of your own conduct, I want to give you nominal damages, you know, give you £1 damages or something like that, and then if there have been any offers, then it could be on the line for costs. Another interesting thing is, although claims in defamation are brought, you know, they're a common law procedure, because and that's why you get damages. Any injunctions are an equitable remedy. And we have all these equitable maxims, one of which is you must come to court with clean hands. In other words, you can only get an equitable remedy if you're all squeaky clean yourself. That's different to common law. You can be the worst person in the world, but if you've got a legal right, the courts can't interfere with that and deny you your remedy just because you're a terrible person. But with equitable remedies, like injunctions, they can say, well, no, why should you get one? Because you're just as bad. The interesting thing there is, even if there was a finding, Barton could probably repeat the allegation, because unlike in the old days where every repetition started the time running again for limitation and you could bring a fresh claim every time somebody said it. The new rule is, oh sorry, you only get one go at this. You got to sue from the first date the statement was made, and the mere fact people repeat the same statement doesn't give you another cause of action. So an interesting one might be Jeremy Vine wins the case, gets nominal damages, ends up paying all the costs, and then can't get an injunction, and Barton can just go and sort of tweet this every time he wants. But we'll have to see. But this came from some great comments on my previous video, so I really appreciate yours. So thank you. Right, as always, hope you found that vaguely useful, vaguely interesting, vaguely accurate. Where am I today? I'm in St Ives. Now, interestingly, St Ives is the patron saint of lawyers, but that's a different St Ives, that's not the one in Cornwall. I found that out after I'd made a video about the patron saint of lawyers outside St Ives Church, and then somebody said, you do know that's a different St Ives. But it's very, it's nice here, and this is a particular spot called the Island, which is like a little, it's not actually an island, because you can drive onto it, but it's like a little headland. It's a very nice spot, although I'm actually hunkered down, you can't see behind me, but there's a massive rock, because it's really, really windy here.